Chào quý vị khán thính giả của đài Việt TV Canada. Hôm nay Molly sẽ giới thiệu đến quý vị một người luật sư đã làm việc chung với Molly trong 5 năm nay. Cô Suzanne Balbataki là một người luật sư đã hành nghề rất lâu và đã biết đặc biệt về những vấn đề như là employment law và civil litigation. Suzanne đã làm trong văn phòng gần 20 năm và Molly sẽ để Suzanne tự giới thiệu. Hi Suzanne, how are you?
Very well, thanks for having me.
Yes, so I've just finished telling the audiences that you are my colleague and I've worked with you for the past 5 years. But can you tell us a little bit more about Spiegel Nichols Fox and yourself, please?
So I'm a partner at the firm, and I've been with Spiegel Nichols Fox since 1991. We're a small business boutique law firm in Mississauga with 10 lawyers, and my practice is largely employment law, employment litigation specifically, and commercial litigation.
And can you give us a little bit of insight into how the marijuana legalization paradigm plays into employment litigation and employment law generally?
So at this point, legalization is something that it remains to be seen what effect it's going to have in the workplace, and obviously the courts are going to have a significant role in determining how employers are going to react to the use of marijuana in the workplace, recreational marijuana by their employees. But to a certain extent, employers are already having to deal with medical marijuana use in the workplace, and so I don't know that legalization is actually going to have that significant an impact on employers if they're sort of well versed on how to deal with medical marijuana under the current laws.
Hôm nay bà Suzanne sẽ nói chuyện với mình về cái vấn đề của cần sa, và bởi vì trong tình hình hôm nay mình đã được dùng cần sa trong một tính cách là như là thuốc men, nhưng mà trong tương lai cần sa sẽ được thường dùng và sẽ được bán trong những cửa tiệm ở Ontario. Và Suzanne sẽ giải thích cho mình nghe sự khác biệt giữa dùng cần sa về lãnh vực giống như là dùng mỗi ngày và dùng cần sa giống như thuốc men, và sự tiếp xúc với employment law ở Ontario hiện nay. Okay, so why don't you take us through a little bit of what you'd like to go through today?
Okay, so I was thinking actually of starting with just a brief summary of how the laws surrounding medical marijuana have developed over the years, and then deal with specifically how it's going to affect the workplace, both medical marijuana and legalization.
Okay.
So in terms of medical marijuana, the bottom line is that medical marijuana use continues to increase across the country, and so employers are increasingly having to deal with the use of this particular drug by their employees. Until June of 2015, the only legal method of consuming medical marijuana was to smoke it. In that year, there was a Supreme Court of Canada decision that held a medical access regime that only allowed access to dried marijuana, basically violated the guarantee of life, liberty, and security of the person in Section 7 of the Charter. And as a result of that court case, there were numerous exemptions established that allowed licensed producers to produce and sell cannabis oil as well as marijuana buds and leaves in addition to dried marijuana. So because of that decision, medical marijuana users can now ingest the drug in a variety of different ways.
So bà Suzanne vừa mới giải thích cho mình nghe là trước đây cần sa thường dùng là để hút vào giống như là thuốc hút, nhưng hôm nay sau tòa trong năm 2015 đã ra những quyết định là về lĩnh vực dùng giống như là thuốc men, mình có thể dùng cần sa nếu cần thiết giống như thuốc men bằng cách uống vô, ăn vô, hoặc là bằng cách dùng bằng dầu. So cái đó là một trong những chuyện đã thay đổi trong gần đây về dùng cần sa bằng thuốc men. So that tells us a little bit of change about how we can consume and use the marijuana. Are there any other recent changes to law that we need to be privy to?
Yes, so in February 2016, there was a decision of the federal court that found that requiring individuals to obtain their marijuana only from licensed producers, again, violated their Section 7 rights under the Charter. And the court found that individuals who require marijuana for medical purposes did not have reasonable access. And therefore, as of August 24th, 2016, a new set of regulations was enacted by the government so that individuals with a medical need who have the authorization of their healthcare practitioner can now access cannabis in 3 ways. They can continue to access quality-controlled cannabis by registering with a licensed producer. They can register with Health Canada to produce a limited amount for their own use, or they can actually designate someone else to produce cannabis for them.
So bà và Suzanne vừa mới giải thích cho mình nghe là vào năm 2016 tòa đã ra những lệnh và hiện giờ nếu mình cần thiết dùng đến và có giấy bác sĩ thì có thể dùng cần sa bằng 3 cách khác nhau. Cách đầu tiên là họ có thể dùng những cần sa mà đã được nhà nước cho phép người ta để bán. Và cách thứ hai là họ có thể lấy một bằng cấp với một Health Canada để mà họ có thể tự dùng và tự trồng và tự dùng một số lượng ít để mà họ có thể dùng về những lĩnh vực giống như là thuốc men. Và cuối cùng là họ có thể nhờ một người khác để mà trồng trọt để cho họ có thể dùng được một số lượng nhỏ đó. And the person who's designated must also be a licensed producer?
No, my understanding is that if you're designating someone to produce on your behalf, it would be subject to the very stringent requirements, the number of plants that you can produce. So that would not be a licensed producer. That would be someone, in their home who, for whatever reason, you can't do it in your own home, but you can designate someone to do it on your behalf.
Okay. And so what happens then if the individual wants to produce just a small amount?
So they have to submit an application to Health Canada. They have to provide an original medical document from their healthcare practitioner, and they have to include information as to the location of where the cannabis is going to be produced and stored. Once registered, the individual then receives a certificate from Health Canada, and that certificate will include information required for the individual to show their legal authority to possess and produce the cannabis. And it will also include the location, the maximum limits of the production and storage activities, as well as the individual's possession limit.
Okay, so I guess this has pretty much changed the framework pretty significantly.
It has. In part due to the changes in the law, medical marijuana has really gained significant traction as a treatment option for a variety of medical conditions. There are currently approximately 75,000 people who are registered under the regulations to use medical marijuana. But according to Health Canada, that number is expected to rise to 450,000 by 2024.
It's a big jump.
It is. And of course, once cannabis is legalized, there's an additional potentially 900,000 Canadians who are likely to start using marijuana recreationally at least once a month.
Okay. So, trong những gần đây người ta đã nhìn thấy được là hiện giờ đã khoảng 75.000 người đang dùng cần sa với tính cách là về thuốc men. Nhưng mà đến khi mà cần sa có thể được dùng thường dùng thì những trong nhà nước đã suy nghĩ đến là có thể gần 900.000 người Canadians sẽ dùng đến cần sa trong lĩnh vực dùng thường lệ, giống như chẳng hạn bây giờ mình uống rượu hoặc là dùng thuốc hút. So, what types of illnesses usually benefit from marijuana as a treatment method?
Health Canada has actually published on its website an extensive list of symptoms that can be treated through medical marijuana. So things like the side effects associated with chemotherapy treatment, nausea, vomiting, loss of appetite, cancer-related pain management, HIV and AIDS-related symptoms, the pain associated with multiple sclerosis, insomnia, chronic back pain, fibromyalgia. There's a whole host of conditions that have been found to benefit from the use of medical marijuana.
Right, so it looks like it's targeting things like pain relief or nausea relief.
Largely, yes.
Largely, yes. And so what happens now? Is marijuana legal really only for medical purposes, and where are we today?
So currently, possession of marijuana for recreational use remains unlawful under the Controlled Drugs and Substances Act. However, one of Justin Trudeau's key campaign promises was to legalize the use of marijuana in Canada. And in April 2016, the government announced that it would introduce legislation in this regard by the spring of 2017. The government appointed a 9-member task force. They delivered their report in December of last year, and the report recommended, among other things, maintaining a separate medical access regime in order to preserve patient access to marijuana for medical purposes. The legislation was ultimately tabled in early April of this year, and it's entitled the Cannabis Act. And if all goes as planned, recreational marijuana will be legalized by July of 2018. And then, if passed, the legislation would permit individuals 18 years of age and over to buy marijuana from a licensed retailer, to publicly possess up to 30 grams of cannabis, and to grow up to 4 plants per residence.
And this is at the federal level.
This is the federal level. So the bill sets out the minimum legal age for sale, purchase, and consumption at 18 years of age. But the provinces and territories can increase that minimum age, which Ontario has in fact done. They cannot lower the minimum age requirement. The bill also contains several provisions targeted at maintaining the safety of young people. The promotion, the packaging, the labeling of cannabis is going to be strictly regulated. And the federal government will be the one to impose the rules and standards governing the cannabis industry. And then, so for example, the types of cannabis products that can be sold to the public, they will establish packaging and labeling requirements. They will standardize potency levels, serving sizes, prohibiting certain substances as ingredients in cannabis. And then it will be the provinces who will be responsible for licensing and overseeing the distribution and sales process.
So, bà Suzanne đã mới giải thích cho mình nghe được là ở lãnh vực federal, tức như là ở lãnh vực của cả nước, họ sẽ ra và đã ra một số lệnh rồi cho biết là tuổi mà có thể dùng được cần sa là 18 tuổi. Và sau đó mỗi tỉnh sẽ có những lệnh khác nhau và những luật khác nhau để mà điều hành những thường dùng của cần sa. 18 tuổi sẽ là tuổi tối thiểu, và sau đó mỗi tỉnh sẽ có lịch trình khác nhau để mà ra những lệnh khác nhau. Như Ontario đã cho biết là 18 tuổi không đủ và họ sẽ lên tuổi cao hơn. Nhưng ở lãnh vực federal vẫn sẽ có những luật để thường lệ ra. Ví dụ như là loại cần sa nào có thể hút, loại cần sa nào có thể dùng. Ở ngoài trong cái bao bì của cần sa phải điển hình như thế nào, và sẽ có những hình ảnh như thế nào. Họ sẽ ra những lệnh để mà cho biết được là ví dụ như là không có thể thường dùng thuốc hút và cần sa chung với nhau trong một điếu thuốc, và sẽ đưa ra những luật đó, và những luật đó thì mỗi tỉnh bang đều phải theo, cho dù là họ có muốn thay đổi cũng sẽ không thay đổi được. Có nghĩa là ở lãnh vực federal là sẽ đưa ra một lệnh chánh, và sau đó ở mỗi lĩnh vực, mỗi province sẽ có những luật phụ. So, I mean, I guess that means that the provincial and local governments will be responsible for sort of their own domain and, you know, the distribution processes. You indicated that Ontario had changed its minimum age. So what is the minimum age of use in Ontario?
Right. So in early September of this year, the provincial government announced that in Ontario, marijuana will only be sold in LCBO-run stores and from a government-controlled website that will also be overseen by the LCBO. The LCBO in turn will get its product from medical marijuana producers who are licensed by Health Canada, and it's expected that there will be 40 standalone stores in place by July 2018. So you won't have cannabis sold side by side with alcohol. They'll be in completely separate storefronts. And the government's expecting that there'll be 150 stores in place by 2020. All the current dispensaries are planned to be shut down. And smoking marijuana will continue to be illegal in any public space in Ontario, including parks, workplaces, and cars. And the legal age for recreational marijuana use in this province will be raised to 19 to keep it in line with the province's drinking age.
And so I guess that means that starting September, we'll start to see some stores with the ramp up ending up with 150?
Right, so July
year.
2018, they're expecting to have 40 stores in place, and then by 2020, they're expecting to have 150 stores in place.
Okay, so the span is two years. 2
right.
years to ramp up to 150
Right.
stores. Okay, so I mean, what does this mean, you know, for how now that it's sort of more, I guess we can say that it's akin to alcohol in some ways, as it's being governed by and sold by and governed by the LCBO. You know, what does that mean for the workplace? What does that mean for employers?
So legalization will obviously have an impact on recreational users in their private lives, since their use is no longer going to be a criminal offense. And obviously many employers are concerned that as to what impact the legalization will have in the workplace. But to a large extent, employers have already been dealing with the impact of medical marijuana use in the workplace. And so I don't think that there will be actually such a dramatic change. So currently employers need to be concerned about two categories of users: medical users and those who are addicted to or have a dependency on cannabis. Obviously, once it's legalized, there'll be this additional category of recreational user. But as you've pointed out, it's really going to be treated in the same way as alcohol is currently treated in the workplace. Employers can restrict recreational use just like they currently restrict alcohol use in the workplace.
Right.
And arguably it's actually more difficult or more challenging for employers to deal with medical marijuana because they have a legal obligation to accommodate an employee's disability, which includes accommodating their use of marijuana if they have a prescription for it.
Right.
So legalization, in effect, is going to require employers to update their drug and alcohol policies. Currently, policies which list marijuana as an illegal drug for the purposes, for example, of workplace drug testing will have to be revised. And similarly, current policies that speak to off-duty illegal conduct will also have to be revised so that the reference to marijuana as an illegal activity, or marijuana use as an illegal activity, would be removed.
Yeah.
But you know, even though it's no longer illegal, policies that govern the use and possession of marijuana at work will continue to apply to recreational users.
I mean, what's interesting is you mentioned like the similarities between alcohol and marijuana, and you know, to the extent that employers didn't previously have plans in place, I guess now it's even more important as there's one more additional substance that can inhibit or affect the way that they act, right?
Right.
So, I mean, how do you deal with that with impairment and use where people actually have the ability where they need skill to, for example, operate heavy machinery?
Right. So obviously workers in high-risk occupations or those who operate heavy machinery will have to restrict cannabis use to be able to function safely. And workplace policies can prohibit the use of marijuana and alcohol in the workplace, and indeed under the proposed regs, the provincial regulations, marijuana use in the workplace will continue to be illegal. And employers also have to make clear in their policies that coming to work while impaired, whether by alcohol or marijuana, is unacceptable. So the legality of it really doesn't matter. Employees can't show up intoxicated or impaired by any substance. Employers are going to have to become more familiar with the effects of marijuana and how those potential effects relate to the kind of work that's required of their employees. But as a starting premise, legalization is not going to give employees carte blanche to come to work while impaired. And in fact, they will be prohibited from using it in the workplace.
Right. So bà Suzanne vừa mới giải thích cho mình nghe là ở cho một người mà đang mướn employees, đang mướn có người làm việc cho mình, một người chủ sẽ có những chuyện khác và gần giống như là uống rượu mà họ phải suy nghĩ đến. Ví dụ những người chủ mà có những người tài xế lái xe hoặc là những người tài xế mà dùng máy móc thì dĩ nhiên những người làm việc trong những tình trạng đó không được quyền uống rượu, và tương đương những người làm việc trong những hãng xưởng đó cũng sẽ không được quyền dùng cần sa. Đó nó không thay đổi gì mấy đến từ hồi xưa tới giờ mình cái lịch trình mà hồi xưa tới giờ một người công nhân làm việc phải theo sẽ không thay đổi gì mấy. Cái mà thay đổi là người chủ nên phải suy nghĩ đến, đặc biệt và dùng nhiều thời gian để mà làm ra những chính sách để cho một người công nhân sẽ phải theo đúng theo, bởi vì hiện giờ ngoài ra chỉ có một uống rượu sẽ có thêm sai về cần sa. So I mean, once legalized, do you think marijuana will just fall into the list of what we see as what could impair employees.
Yes, but the difficulty with marijuana will surround the issue of impairment, because unlike alcohol, there currently is no standardized testing method that can measure impairment the way that we can for alcohol. Workplace policies are going to have to define impairment and fitness for duty, and there's going to be debate on what impaired actually means when it comes to marijuana. Policies will still need to identify how marijuana impairment can be identified in the absence of a definitive blood alcohol test. And employers may have to rely, at least for the time being, on more subjective ways to assess use and impairment. But assuming that an employee is impaired by virtue of recreational marijuana use, and as a result can't perform the essential duties of his or her job, then legalization is not going to prevent an employer from disciplining an employee whose performance is adversely affected by that recreational use.
So bà Suzanne vừa mới giải thích cho mình nghe là hiện giờ ở trong những công ty thường lệ nếu mà mình phải hoạt động về có những máy móc lớn hoặc là phải lái xe thì một người chủ có quyền và sẽ có thể dùng được những máy móc để mà thử coi mình có sai hay không. Nhưng cần sai nó khác, bởi vì hiện giờ mình chưa có những máy móc và chưa có những tính cách nào đó để mà có thể thử coi cái người công nhân đó có sai bởi vì cần sai hay không. Nói cách khác, sai vì rượu dễ thấy và dễ thử, còn sai vì cần sa khó thấy và khó thử. Does that mean that we just have a gap until the technology catches up the way that we have breathalyzers with marijuana use?
Right. Yes, and I mean we've seen that in the media. You know, the police are also struggling with how they're going to deal with impairment in the context of driving, because right now there isn't an effective testing mechanism that will measure current impairment versus use, and that's in large part due to the fact that marijuana impairment can differ greatly between two individuals depending on the extent of their use, the strains of marijuana.
Sure.
And there is going to be that gap until we have the technology that allows employers to effectively test for impairment.
Okay, I mean, it's a lot to think about, especially for employers who have employees who use heavy machinery or operate vehicles or such. It'll take some time for the whole industry to catch up. Assuming that there's the requirement over and above safety, what can an employer do to implement sort of their ability to test? What can they do to come up with a policy that is within the realm of kosher for employment law purposes?
So if you're referring to drug testing specifically, that's a very thorny issue in Canada, and there are really two types of testing that need to be considered. Random testing, and then what's known as reasonable grounds and post-incident testing. So there are actually very few laws in Canada governing drug testing, but unlike in the United States, courts over the years in this country have significantly restricted when and how employers can randomly drug test their employees. In unionized workplaces, the Supreme Court of Canada delivered a decision in 2013. It was called CEP Local 30 in Irving Pulp and Paper, that brought some clarity to the law. In that case, the employer had unilaterally implemented mandatory random alcohol testing at its paper mill, which undoubtedly is a safety-sensitive environment.
Sure.
But the court affirmed that random, in that case, the case actually dealt with random alcohol testing, but the same principles would apply.
Sure.
And they found that such testing was not automatically justified on the basis simply that the workplace is dangerous, and that employees are in safety-sensitive positions. The court found that an employer can only impose a rule with disciplinary consequences if the need for that rule outweighed the harmful impact on an employee's privacy rights. So that's really the balancing act that the court has to perform.
And mere need for safety was not sufficient.
It was not. In a safety-sensitive environment, employers are generally entitled to test employees on a case-by-case basis in three circumstances. So if there's reasonable cause to believe that an employee was impaired while on duty. Secondly, where the employee was directly involved in a workplace accident. Or thirdly, where the employee is returning to work after treatment for substance abuse.
So it seems like all these three factors, with exception, are somewhat ad hoc. It's after it happens that the testing is
Correct,
allowed.
right.
Okay.
Well, unless you've got a situation where someone appears to be visibly impaired, and then you could say that you have reasonable grounds to test the person. But just random
but even
testing,
that, you must notice first the symptoms before
correct.
you can administer
Yes.
the test.
Mhm.
Yes. So từ hồi xưa tới giờ mình đã có luật bắt đầu từ 2013. Tòa đã đưa ra những lệnh là nếu muốn một người công nhân phải thử coi coi họ có bị sai về rượu hay không. Trong 2013, trước khi cần sa được thường dùng, thì lúc đó mình phải thấy trước nhất là người công nhân đó, người chủ phải thấy, hay người manager phải thấy được là nhất đầu tiên là người đó có thể bị sai. Thế nhìn phải nhận xét được là có thể họ đi không đúng hoặc là nói chuyện không ngay, cho nên phải có lý do để mà mình nghĩ là người đó đã bị sai trước khi mình có thể kêu họ thử rượu. Thứ hai, nếu mà họ dùng hoặc là bị một vấn đề nào đó mà tạo ra một accident trong khi làm việc, lúc đó thì mình có thể kêu họ thử. Và cách thứ ba là nếu mà người công nhân đó thường lệ có vấn đề là hay thường say sưa hoặc là đã bị bác sĩ đưa giấy bác sĩ ra là người đó thường bị nghiện rượu, lúc đó thì người chủ có thể dùng và kêu người công nhân để mà thử rượu. Thì bà Suzanne vừa mới cho mình biết là những tình hình đó sẽ tương đương với những tình hình mà mình có thể thử về cần sa.